carrying out activities near the war risks areas. And a handful of vessels have already been damaged. And in terms of the aviation losses that the ships stranded in Russia, I started sort of reading articles, and then they were mentioning about like 100 aircraft. Then another article was saying 200, then 300, then it became 600. I'm not sure if anyone knows the exact number of aircraft stranded there, but you can imagine that the loss is huge, billions of dollars of losses that is being questioned. And there was an interesting comment about cancellation of insurance contracts. And there were some comments that insurers really must not be cancelling the contracts, especially whilst the coverage is in the grip of an insured peril. It's obviously a contractual matter, isn't it? So one has to look at under what circumstances cancellations are permitted. And if it is permitted, then obviously it can be done. I mean, there might be some arguments there about the breach of good faith, but that's obviously a topic for another day. And non-payment of insurance claims for sanctions. There are some interesting developments because, for instance, this morning, the Foreign Secretary, the United Kingdom Foreign Secretary said, as soon as the Russian forces leave Ukraine, then sanctions will be lifted. So in this respect, so that the effect of sanctions probably will be assessed together with that. So what's the prospect of it? So are they going to be lifted or not? So when it comes to the insurance law matters, if we go into sort of more specific issues, in determining all of these general areas, so how can they be resolved, and what sort of principles might help us if we are dealing with contracts with Ukraine or Russia? What sort of issues that one has to bear in mind in order not to jeopardize the insurance claim? So there seem to be at least lots to learn from previous cases. And in this respect, I'd like to talk about Royal Boskalis versus Mountain case. That is a case decided with respect to losses occurred when Saddam Hussein invaded Kuwait. But you could easily draw some analogies between the facts as occurred in this case and the current war situation. You could simply change the parties, and then you could see that something similar might occur. For instance, if in case you try to recover the stranded aircraft from Russia. And this case shows how not to do things. So in this case, the claimants were Dutch companies, and then those Dutch companies, they had agreements with the Iraqi government, and what they were doing was dredging. So obviously the petrol resources, and then they were using the dredging equipment and personnel there. So far, so good. They have an agreement. The agreement was governed by Iraqi law, and it says in case there is a dispute, arbitrate it in Paris. And the dredging was insured with London insurers, including having a sue and labor clause, which is a quite wise thing to do, because if the assured wants the sue and labor expenses, there has to be an express clause in the contract. And the insurance contract was governed by English law. It mattered a lot. So the original contract is governed by Iraqi law, the insurance contract was governed by English law. So insurance claim arose. Why was it the case that this insurance claim arose? It was because when Saddam Hussein invaded Kuwait, then the United Nations sanctions followed. When the United Nations imposed such sanctions, the Iraqi government obviously counterattacked and said, well, if you have anything in my country, and if you are going to adopt the sanctions, I'm going to seize whatever you have in Iraq. Now the company is panicking because it has personnel in Iraq, it has dredgers in Iraq, so they have to save them. How are they going to save them? Then they made an agreement with the Iraqi government. That was called finalization agreement. And the Iraqi government said under the finalization agreement, okay, you can you can have your personnel, you can have your dredgers, but then waive all of your rights for fee under the contract. So we are not going to pay you any penny, and transfer some money into our bank account. The deposit that you paid before, transfer it to this bank account, they said. So the Dutch companies, they did that, and they saved the personnel, they saved the dredgers. So if the dredgers had been left there, what would have happened? They would have made an insurance claim. But the dredgers, they were saved, so they didn't need to make any insurance claim. However, they said that the fee waiver plus the deposit we transferred to their bank account, so it was unusual and extraordinary. The objective was to preserve the insured property from loss by an insured peril. The insured peril was operative and imminent. The loss, if it had occurred, would have been recoverable under the policy. The steps we took, they were reasonable. So we should be able to claim what we lost as sue and labor expenses. First question was this: well, you didn't pay anything. You simply waived something that you were entitled to. The insurer said, these are not expenses as you can claim sue and labor. But the court denied that. The court said that if the sue and labor expenses are recoverable, it doesn't matter whether you waive it or whether you pay it out. So you are entitled to recover that. Okay, fine. But the problem was the original agreement said arbitrate in Paris. The Dutch companies, they should have taken the issue to Paris, to arbitrators. They shouldn't have settled it. So obviously you cannot say that if you have an agreement with the Russian government, don't settle it if it says that, for instance, go and resolve it with an arbitrator. So you need to take it to the arbitrators instead of settling it, because this case says, don't do it whatever the underlying contract says. And the agreement was valid under Iraqi law, but the court discussed its validity under English law nevertheless. So if you are making, therefore, a claim under English insurers, and although the original, this underlying contract is not governed by English law, English courts might still analyze it under English law due to public policy reasons. Why is that? Because the finalization agreement was taken out under immense pressure, duress. If you enter into a contract with this pressure, it's not enforceable, it is avoidable. And here actually the court said that not even avoidable, the court said null, void, unlawful. So it may be lawful under Iraqi law, but the court said that what you are trying to do is, by applying to the English court, you are trying to enforce something null and void under English law. So we are not going to enforce that, the court said. We are not going to support that an agreement taken under immense pressure, that we are not going to allow a claim by relying on that. So apparently there were death threats against the people who were negotiating. Those people, they were later rewarded by the King of the Netherlands, but that was another matter, and then insurance claim was another matter. So the finalization agreement was problematic, although the governing law was not English law. The court said that what should have the company done? It said arbitration. They should have gone to the arbitrators. And the arbitrators, in the view of the English courts, the arbitrators would have rejected to enforce the agreement between the Dutch companies and the Iraqi government for the same reason, that it was entered into under immense pressure. The court said that what is the loss that the Dutch companies suffered here? We need to look at the actual loss, not the notional loss. So what would have happened had they gone to the arbitrators? The arbitrators would not have enforced the finalization agreement. So before the finalization agreement or after the finalization agreement, there was no difference between the parties, this Dutch company's position financially. Before the finalization agreement, they didn't have the fee, they couldn't get that. After the finalization agreement, because the agreement could not have been enforced, they didn't lose the fee anyway. As a result of which, what the company claimed was not supported by the English court principles, the principles that the English courts applied, and they couldn't claim anything. Yes, they saved the dredgers, they saved the personnel, of course, very important, but the fee they waived, they lost it. The deposit they paid also, it is important because, again, it is, you can apply this in today's positions. And at the time, the court said that the payment that they made when they moved the deposit from one account to account that the Iraqi government wanted, that was illegal. They shouldn't have done that because that was breach of sanctions. So hence, they cause their own loss, and we can't possibly enforce that and then award them damages for something that actually they shouldn't have done. It was illegal. So you could have thought that actually what they did was reasonable. Under the circumstances, they had no other options. But when it comes to making a claim against the insurers, reasonableness play very little role, if they play any. They play hardly any role. And then when it comes to what caused the loss, why did they suffer loss, reasonableness, if you're going to make an argument on the basis of reasonableness, you always have to have some other valid legal grounds as well to support maybe that. But reasonableness on its own, unfortunately, when you look at the cases, there seems to be like a pattern there. So on the basis of reasonableness only, hardly any that an insurance claim is supported. One example on this is you can look at a case from the First World War, that's Becker versus London Assurance. And then you can regard what the captain did here or what the assured did here, perfectly reasonable, but it wasn't enough. So this was about a carriage of goods from Calcutta to Hamburg. British trader, German trader, they made an agreement. And the cargo was loaded on a German ship. And when the cargo was sailing towards Hamburg, war declared between Great Britain and Germany. So imagine, put yourself in the captain's position. Now you are sailing towards Hamburg. You are a German ship carrying British cargo, and there is a war now between Germany and the Great Britain. And are you going to keep sailing to Hamburg? Are you going to abandon the voyage and sell the cargo and make a claim against the insurers? Because you also received a letter saying that if you are sailing in the Mediterranean and if you're a German ship, you are under the danger of being seized. You will be captured. So you received this letter, you received this warning, and you are then you seek shelter in a port which is a neutral port. Now, then you are making a claim against the insurers. When you are making a claim against the insurers, you are going to argue that, okay, what caused the loss? Because every time you make an insurance claim, you have to prove what caused the loss. You can't say that my reasonable action caused the loss. It wouldn't be heard. So there has to be something that insured peril that caused loss. Here, capture was an insured peril. Did the capture occur? No. What did it occur exactly? You avoided the capture. So are we going to then accept that here? You avoided the capture because it was almost unavoidable that it is going to happen otherwise. So shall we accept that the peril occurred? So the court said no, the peril did not operate. Here, what the captain did was simply avoiding the danger. Yes, there was the letter from the Admiralty saying that, or if you sail on the Mediterranean, you are likely to be captured. But nevertheless, still, the court said, well, yeah, you got the letter, but you didn't know whether the enemy had known that that ship was going to sail there. You don't know how many ships were there waiting to capture this ship. You didn't know that. This I find it quite stretching, this reasoning. But nevertheless, that's the House of Lords decision. So the House of Lords said that here, the assured said that, well, we had no other choice. What were you expecting us to do? Just to sail by knowing that we are going to be captured? Because if you do that, then you might be regarded as having caused the loss recklessly. You are causing it instead of avoiding the danger. Here, the captain avoided the danger, but it wasn't enough. The court said, well, I don't say that he ought to have done otherwise, but he could do as he liked. He might have picked his own time. He might have weighed his chances at leisure. Reasonable delay wouldn't amount to abandonment of the voyage. Even an early peace was not wholly beyond the bounds of possibility. So in a way, the House of Lords was saying that instead of abandoning the cargo, they should have just waited until there was peace. But I think that this is really problematic, because if you look at the cases established constructive total loss, if you abandon a voyage because actual total loss is unavoidable, it's a constructive total loss. And this rule was developed because the war was open-ended. You don't know when the war is going to end. Do we know now when Ukraine war is going to end? Do you have any prediction? So because you don't know it, then there is this constructive total loss concept had been developed. But here the court said that the exact opposite. Well, just wait until the war ends and then the peace is achieved. I think it's a very unfortunate case for the assured. So another thing that the court said that, yes, here capture, enemies, war somehow influenced it, but it was a remote cause. The problem is the proximate cause has to be identified to decide what caused the loss, efficient cause. The court said that the efficient cause was the master's self-restraint. War was not the efficient cause. So there were obviously some of the cases decided before the Becker case. Butler versus Wildman, for instance, in which that the ship was carrying cash and was about to be captured by an enemy, and the captain just threw away the cash that was on the ship because he didn't want, obviously, the cash to be captured when the ship was captured. And this was accepted as total loss. Occurred because of a capture. And in the Becker case, the court said, ignore Butler, it's just illogical. In Hatkinson and Kasyanov cases, similar to Becker, that the ships were sailing through Naples, and when they were, during the voyage, the captain received intelligence that don't sail there. If you sail there, you are going to be captured. Then the captain just abandoned the voyage, and then the cargo was sold. When there was a claim against the insurers for the loss of the cargo, it was rejected, and the court accepted that the insurers were not liable for the same reason as Becker, that it was simply avoiding the danger. The peril did not operate. But Sunday case is different. In the Sunday case, the British ship loaded with cargo, carry it again to Germany, very similar to the Becker case. Again, they received that the war declared between Germany and the United Kingdom. The ship sailed to Liverpool, another ship sailed to Glasgow, and they made a total loss claim for the loss of the cargo. And it was accepted. It's totally exactly opposite of the Becker case. But why? Why did the court decided in Sunday that there was a constructive total loss, but in the Becker case, there was no constructive total loss? Now, in this Sunday case, the court said that this is important. The court said that what is insured was the entire voyage, the safe arrival of the cargo. That's the subject matter insured. And here, the safe arrival of the cargo is not possible anymore because of the war. And that's why the journey was abandoned. And the court said this here, constructive total loss. The insurers argued this. It is not the war which caused the loss. It's the law of the land, which is saying that don't trade with the enemy that caused the loss. But the court said, no, here you are not separating it. War and the law saying that don't trade with the enemy, it's the same thing. So it's one thing. You can't separate these two. So war caused the loss. And in Becker case, the court distinguished Sunday, and the court said that, well, in Sunday, the court decided it this way because the trade became illegal. I think in Becker, Sunday was misunderstood or misread. That's not what Sunday decided. So in the Sunday case, which was decided before Becker, the insurer said this: if you say that because of the war, the cargo was constructive total loss, all the cargoes belong to on the ships that His Majesty is carrying His Majesty's flag. They were all constructive total loss. In Sunday, the court rejected that argument. In Becker, the court accepted the same argument and said, if we say that here the cargo became constructive total loss, we have to accept that because of the war, any other cargo under the same circumstances have to be constructive total loss. It's illogical. Would you win or lose? The same argument, but you can see how the courts interpreted them differently. So frustration of the adventure, therefore, it is normally a constructive total loss. And when the adventure is frustrated, you don't look at whether the cargo is damaged or lost. You don't look at whether the ship is damaged or lost. The whole idea is that the adventure is frustrated. But the court obviously rejected that in the Becker case. So basically they said, destruction of the contemplated adventure? Nope. The subject matter of insurance was abandoned on account of its actual total loss appearing to be unavoidable? No. Direct loss by enemy? No, because the cause was not the enemy, it was the master's voluntary decision. So the court simply said that this was master's civil wrong. So that was nothing to do basically with the risk of an enemy. So I find therefore Becker case quite controversial. It's quite obviously insurer friendly, and if there are today claims that are made because the ships or cargo tried to avoid the war, if the insurers reject payment, obviously Becker is an insurer friendly decision, but Sunday is there as well, and so there are lots to be said about what Becker said about this and how Becker read Sunday case. And this Nobles versus Jenkins case is a below lading case. In case you're dealing with below lading, which contains a restraint of princes exclusion, for instance. In this case, the court accepted that if the master keeps sailing, despite the danger of a capture, the court said that the master would be acting recklessly. If the master stops sailing, abandons the voyage, that comes under the restraint of princes. But this is not an insurance case, it's a bill of lading case. And it was decided before Becker, before Sunday, but it's the first instance decision. It's not a House of Lords decision. It can only be a persuasive, maybe, authority that you may want to rely on in case. And another matter I'd like to touch upon here is, if you exclude war risks from the policy, or if you cover war risks in the policy, is this going to include cyber risks? You might have heard about this decision. I'm not sure, because it was obviously some time ago. Again, it was decided January 2022. And in this case, what the court discussed, but this is an American decision. So far, I have only mentioned about English decisions, very insurer friendly. This is an American decision, and in which case the court discussed war risks exclusion and whether war means, in its traditional sense, war, like missile attacks, rather than cyber attacks. And M's computer systems were infected in this case, and there was an all risks policy, obviously covering all risks, but for the exclusions. And there was an exclusion here, warlike action exclusion, which excludes damage caused by hostile or warlike action in time of peace or war, and any actions by government, sovereign power, military, naval, air forces. And the question was whether this clause included the war in its traditional sense, or did it include cyber risk as well? So this was a pure interpretation of this clause, whatever this clause said. Now, interpretation, what does this mean? Interpretation means you read this clause and you try to figure out what the parties understood of this clause at the outset of the contract. So the court said that insurance contracts or contracts of adhesion, and there's this great imbalance between the insurer's understanding of the contract and the assurer's understanding of the contract. So when you decide what a clause means, you always bear this in mind. But remember, this is an American decision, and this is what Americans say. In English position is not always as assured friendly as this. And obviously the sophistication and knowledge of the assured matters. And in this case, Merck was a sophisticated assured, but the court said there's no evidence that they discussed the war risk exclusion individually. So we don't regard it here that we are going to put insured and assured at arm's length, but the assured is still in a vulnerable position. We look at the plain meaning of the term. So here, plain meaning, all risks policy. What does this mean? All losses of a fortuitous nature, accidental, but for the exclusions or deliberate action of the assured is covered. Insurance policy exclusions, the court said, they are interpreted narrowly, strictly construed against insurer. If there is more than one possible interpretation, courts apply the meaning that supports coverage rather than the one limits it. This is very American. In English law, there is no hard and fast rule as such when it comes to interpretation. The insurer must show that the assurer's interpretation of the exclusionary clause is entirely unreasonable. Again, it's very American. The insurers, they don't have to prove that the assurer's interpretation is unreasonable if you are dealing with an English insurer. So warlike action exclusion. So the court said that, okay, ordinary meaning of hostile and warlike operation. What does this mean? Warlike, like war, the court said. Hostile should be understood as the use of armed forces. So both the insurer and the assured were aware that cyber attacks of various forms, sometimes from private sources, sometimes from nation states, have become more common. So when they entered into the contract, of course, that the parties had known that. They put this war risk exclusion from the cyber risk cover, but what they meant was, at the time, they insured cyber risks. They excluded war risks. They meant only war which uses armed forces. This is pure interpretation. And so the insurers, the court said, could have selected a different wording, but didn't. If they didn't select another wording, then the court also took into account that this has been a clause which has been used for some time. You can see that so many things can influence how a clause is interpreted. Finally, I could have put some obviously explanations on this on the slides as well, but I didn't want to just prolong the presentation, just unreasonably. So hostilities and warlike operations, the meaning of them, they were also discussed in English cases. And the courts actually established that warlike operations are a broader term than hostilities. Hostilities, it means that sort of connotes the idea of belligerence, because that properly so-called enemy nations at war with one another. And it is used to describe the operations, offensive, defensive, protective operations. But they said warlike operations, it doesn't necessarily require a state of war. Maybe state of war does not exist, but it still includes some actions like war. So you could probably argue, by arguing warlike operations, that cyber risks can be included in this. Interestingly, in the Merck case, the court referred to the King case, Britain Steamship versus the King, which discussed hostilities. But they didn't refer to Yorkshire case, because Yorkshire case, if you look at that, warlike operations, a broader term, that could actually include cyber attacks in the warlike operations exclusion, but they didn't refer to it. Maybe it was intentional. I don't know, because if they referred to the Yorkshire case, then it would have worked against the assured. They only referred to the King case. So American decision referred to an English case. So it's just there is this difference between hostilities and warlike operations, and the courts recognize this in their own definitions. That's all what I would like to say about war risks. I hope that this can at least help you sort of compare what happened in the past and what's happening today. And if you have any questions, I'm happy to answer as much as I can.
Thank you very much, Professor Odlem. I think you as always, taught us a lot of things related to war risk and how this has been interpreted by the courts, not only by the English law, but also by the American law, which, as you explain us, they have like different visions regarding if one of them is more insured friendly or no. So thank you very much. So we have some questions here. In case you have additional ones, please just drop the questions in the questions box. I think you have it in the upper or in the lower part of the platform. So people want to know like your opinion and what do you think about the impact of the war, in terms, if the impact of this war, of the Russian-Ukraine war, in terms of insurance could be similar to or perhaps greater than the impact of the attack to the Twin Towers back in 2001. Like, if you are, do you think there's like a parallel to be that could be made between these two wars in terms of insurance. Maybe if I'm missing something, sorry. This is what I can catch from the question that is being made.
Well, the only parallel I could put there is obviously what may occur after that. So whether the hostilities, they would still carry on between different nations. I think that was one of the obvious impact after the attack, the Twin Tower attack. And that's the impact now. That obviously one country is there, it seems like many other nations is on the opposite side. But then, and also the other similarities I could draw is the amount of the loss obviously there. And it was obviously huge to the United States economy too. And obviously this war is affecting lots of economies. Probably the war now, the impact of it is broader than simply the Twin Tower attacks. And that's obviously a terrorism and a one-off thing obviously happened. And it was just basically happened in one morning. But then now you have the war, which is ongoing. And obviously the impact is a lot broader. After you would question, obviously, the insurance in terms of the future of insurance, what's going to be insured from now, what's not going to be insured. For instance, the impact of it in the USA, that the insurers, they didn't want to insure against terrorism anymore. And the government therefore adopted one act, which is in a way encouraging the insurers to insure terrorism risks. But now obviously we are talking about insurance of war risks and whether the insurers will still keep insuring war risks is another, that you can see the similarities maybe there. So if you are going to be trading around that area, you may find maybe the insurers, insuring it may be a bit difficult. But at the same time, obviously, you may know that obviously if one risk is not insurable elsewhere, it normally goes to London because of the subscription market. So, and then insurance and reinsurance availability is there.
Yeah, and I think this last part that you have mentioned could be connected with this following question, where people is asking if do you think after the war, the non-war exclusion will be modified by insurers? I think people want to know if perhaps it is going to be like a little bit like strength in terms of defining what is war, and for example, if indeed cyber attacks would be included or not. Do you think this exclusion will be modified after this war?
Certainly. I think in that respect, we need to keep an eye on the committees who develop exclusions, war risk exclusion or war risk coverage clauses, because to my knowledge, they've been working now after the Merck decision. They are trying to deal with the obvious war risk exclusions, what to include, what to exclude. I personally am not expecting major changes in terms of the wording of the clauses, but it's my own personal view. The reason is this, is that now the nature of insurance, what we try to do is always to predict what's going to happen in the next 12 months or so, because insurance is basically on that basis. What risks may occur and how they may occur, we are trying to predict it today. And no matter what sort of form you are going to give a clause, the nature of insurance is always the same. Always, you are putting that clause today, trying to predict the future. A year ago, those clauses were put in the contract, but the future was unknown, and then there is war now. Or before COVID-19, we were putting infectious disease in the insurance clauses, but then COVID-19 was not written there. So now you exclude COVID-19 or you exclude this war and that war, but something else might happen in 6 months' time. So no matter how hard you try to have sort of contractual changes to be able to respond what's going to happen in the future, I'm a bit skeptical that the accuracy, how accurate you can be. I think it's pure matter of chance, luck.
Yeah. There's another question which says, how does the inflation caused by the war is affecting the marine and property insurance? If you have any opinion regarding this.
Sorry, I missed the first part of it.
It says, how does the inflation caused by the war is affecting marine and property insurance?
Yes. The only thing I know is that the insurers are not that much worried about the paying or not paying about the war risks claims at the moment. Hence, maybe the insurance premiums, they may go up a little bit, but I don't think they are going to become uninsurable, because the responses of the insurers, when I read some comments, I was quite surprised, because after COVID-19, for instance, the insurers, they were mostly arguing that, we can't pay those claims. It's really just far too big than what we insured against, much bigger than us. But then now they are saying about this war risks claims, they are saying that, well, of course we are going to compensate the losses, because that's the reason why we insured against these risks. So I am not, therefore, as much as I read, as much as I heard at meetings, so I didn't hear that there's going to be, major earthquakes, if you like, in the industry.
Okay. And I think we have space for one last question, which says, in your experience and regarding or in connection with anything you have heard in London and from the Lloyd's market, which coverages do you think are likely to be the most affected? I mean, if I think they're referring to if the most affected will be aviation risk, property risk, or what about, for example, cyber attacks? Because I've heard that aviation has been really, really affected. And I don't know if you agree with this or...
Cyber attacks have always been a constant worry. But the thing is, you don't know. You don't know whether there's going to be a cyber attack, and if there's a cyber attack, who is behind it, you don't know it either. And whether cyber attack comes within the definition of war is a question. Mm-hmm. And I mean, if you look at the Merck decision, it is simply a decision on the clause discussed in that case. So you can't say that, for instance, coming from that case generally, any war risks exclusion or insured clause ensuring war risk, that includes or excludes cyber risks. You can't really come up with an answer as generally applicable like this. All the time you need to look at the wording of the clause as a whole, read it within the contract in the context, and decide whether it includes cyber or excludes it. It's the unknown nature of cyber risk is always there. You deal with it now as you dealt with it before. But it's a concerned definition. That's what I know. The second thing I know about the risks is that aviation, again, it's obviously the insurers obviously are not really happy what's happening because they are talking about $13 billion worth of loss. But the fact that the losses are reinsured, it's giving in a way a little bit relief to the companies, because obviously the reinsurers' backing is there. And it's just that they obviously have to be very careful that in case they pay out the claims for the loss of the aircraft, they must do that without breaching the reinsurance contract. So they should pay attention to their obligations under the reinsurance contract and make sure that they comply with that. And they say that also the credit insurance is that obviously that's not really provided by traditional insurance companies. That's provided by credit insurance institutions in every nation where credit insurance is possible. That they say that that would be problematic because in case, for instance, you sold something to Russia and then you didn't receive payment, and you can't receive payment now because of sanctions. So these things obviously would trigger credit insurance.
Yeah.
So that's also another issue. And whether you had political risk insurance, again, if you suffer financial loss like this because of the political decisions, sanctions, etc. And I mean, property, obviously, we know that, don't we? So it's rather straightforward insurance claims.
Exactly. So I think that's all. Özlem, thank you very much for sharing with us all your knowledge and all your experiences regarding this topic, because, and of course, you are more closer to the world than us. So thank you very much. It's always a pleasure.
Thanks for giving me the opportunity. Thank you. Thanks very much. And I hope to see you somewhere soon, Mallory.
Yeah, so I think I'm planning to go again. So I hope we can see each other again. Lots of news for sure.
Great. Look forward to it. Okay. Bye.
You. Diego, I don't know if you want to close the webinar with something.
Yeah, thank you so much, Professor Gorses, Professor Zafra, for joining us today. It was such a wonderful event. I'm sure it was a great opportunity for our young members to deep a little bit in these topics. We are very grateful, and we were very lucky to count with you today.
Thanks again. Have a great day. Bye-bye.
Bye.
Okay, thank you very much. Bye.
For all the attendees, thank you for joining us today. Muchas gracias por habernos acompañado a todos los asistentes el día de hoy. Les enviamos un saludo muy especial. No. Tranquilo, yo creo que ya ahí podemos dar por terminado, y al que está de host, que por favor cierre la sesión. Muchas gracias para todos. Estaremos informando nuestro siguiente evento. Que tengan un feliz día.
Chao, Dieguito.
Chao, Mar.